Welcome again to our course on biodesign, strategies for innovation and design on bioengineering. Today we're going to start a series of lectures on strategy. As you have seen, we have already explored some of the basics of all the different steps and parts that the biodesign process includes. In this sense, we have go from the basics of performing observations to detecting problems, to stating them, to trying to solve them, and even prototyping concepts and selecting your final concept solutions. Throughout this process, we have already explored some basics on regulatory affairs, some ways to perform clinical testing, and of course, intellectual property, which was the chapter 4.1. Today, we're going to go in a little bit more in depth on how to create an intellectual property strategy, which is something that it's going to be really important for you to acknowledge, since not all IP that you're going to find is permissive, and so you want to have a strategy for how to circumvent that, or even exploring another field in which there is a more open space. So as you're going to see, we're going to have strategies for that too, and for that is the class of today. So let's start. The objectives for today's class are basically to understand the strategies involving filing a provisional and utility patent applications and why that's useful. Also, I want you to appreciate how to conduct and utilize a freedom to operate analysis, or FTO analysis. I want you to understand also when and how to hire a patent attorney. As you're going to see, this is going to be something really important for you to know, because not every legal aspect of your medical devices can be fixed by you. So maybe you are going to be able or needed to have a patent attorney at some point. Also, I want you to understand how to review the basic strategies of international patent filing in order to be successful, to appreciate the importance of an ongoing patent management strategy, how to consider the different basic defensive and offensive IP portfolio strategies that we are going to explain today, and to finally understand the basic features of a patent litigation in the medical technology field. Okay, so when thinking about all the objectives of this class, at the very end we're talking about risk. We're talking about intellectual property risks. And in this sense, you're going to have three main spaces in which your IP is gonna move. In this sense, there is a space of high risk for your IP portfolio, a medium risk space for your IP portfolio, and a low space risk. And as in any other characterization of spaces and risk, what you're going to have is a status of how does a high risk level IP space look like, and also the required actions that you have to take in order to try to cope and manage your situation in that specific space. So let's think about these risks. We mentioned that there are three types: high, medium, and low. So with the high IP relative level of risk, what you're going to see is that your status is, you are probably going to be defined as in a high IP risk landscape if your IP has multiple patents that are in direct conflict with yours. Especially issued patents or granted patents. What you're going to have is that this is a high-risk IP space. It's a space in which claims are written and indicate things very, very similar to what you want to invent, or in the space in which you want to innovate and create a company. The required action in this sense is to undergo an exhausting claim analysis. So something really important to know from this moment on is that every single patent in the world can be circumvented. This is a wide knowledge. Every single patent can be surrounded, and you can create ways and strategies to go and to pass by through a patent. Also, these practices are in the realm of art, but of course that can be an easy thing to do if you have the right tools to create an exhaustive claim analysis. And also, to another strategy in which you can act if you are in this space, if you have enough money, is possibly to enter into a licensing agreement with the person or company that holds that IP that it's blocking you. Also, there is a topic or a strategy in which you can develop a risk mitigation strategy for trying to see if in which nations that IP portfolio hasn't been protected, and so on. In this case, it's again very important to understand that every single patent can be surrounded and that you can enter into that space if you have enough knowledge of how to circumvent claims. If being in a space of a high IP risk level, it's very, very convenient to hire a patent attorney to help you figuring out the best way to circumvent this, or the best way legally, economically, and strategically to cope with this problem. So going down in risk, you have also the medium level risk, in which is probably one of the most common places to be, in which there is a space that has a small buzz. There are some actors that have already applied for patents or having even issued patents, and in this moment you know that you are probably in a medium IP risk level. You know for sure that you are in this scenario if there are patents that are filed with claims that are similar but really not that pressing for you as in a high risk level position. In this sense, what you want to do, the actions that you want to take is to create a comprehensive claim analysis again, but design it to try to come up with more innovative or different claims than the ones that have been already issued or submitted, in order to develop a more a stronger portfolio. Also, what you want to do is to also create a mitigation risk strategy, in which, in case there was a patent that you never explored, you have a plan of how to license that or have the money to cope with the legal issues that could bring. At the third place, you have the low IP risk level position. This is a place in which everybody wants to be. Basically, you know that you are in a low risk IP space if there is a wide open IP landscape. So nobody is actually nobody has ever submitted any for patent that resembles anything that you're trying to do. This is a very compelling place to be. Nonetheless, it's really rare for someone to enter into a space that nobody else has explored. Nonetheless, there are times in which that can be possible. In this case, what you want to do is, instead of trying to come up with strategies of how to prevent others from noticing that you are entering into that space, what you want to do is to develop a strategy in which you create enough IP to become dominant in this field, so that if anybody wants to enter into that field, that evidently has to have, for the biodesign process, a large market, a compelling clinical need. If somebody else wants to enter into that field, you have already covered most of that, so that they have to license your technology or collaborate with you. In this way, in this sense, the value of IP is evident as value is increasing, and value increases in IP from the moment that you protect to the moment that you create a business and that you monetize your products. Something really important to know is that really a patent is not worth a dime unless it is used and it is used to commercialize products and to protect others from producing a valuable asset. In this sense, a strategy to create a strong IP portfolio is not only to create a lot of patents that cover you from many sides, but that also to encourage people to license your technology, or companies, or also to encourage your company to utilize most of the patents that you have already filed, in order to increase their value towards a business strategy. In this sense, you have different layers of this pyramid that starts again with protecting the inventions, but then it goes on and on with managing the competition through building a stronger IP portfolio, ensuring design freedom so that you don't have to pay someone else to license a technology to produce a certain product. Also to build the market so that the patent is not only issued, but that it's also producing value or protecting others from getting value that belongs to you. And of course, at the end, delivering revenue and creating a sustainable business model. At the end, the very ultimate value of an IP portfolio is that it protects your business somehow. But without a business, there is no value whatsoever in any patent portfolio, and that's something really important for you to know. Okay, now that we have explored how the different spaces of IP go, and what are the stages of creating value, real value in an IP portfolio, we can think about some of the strategies, defensive and offensive, that are going to be for you to create a strong portfolio. So in this sense, the first one that we're going to explore is the defensive IP strategy, which is called also the picket fence. In this case, really simply, you are the innovator that have a core IP, and what you want to create defensively is a series of patents, or at least one, that creates a blocking path for other competition to enter into your core IP. So what you're going to do is to create a fence that it's either bigger or stronger, so that nobody can pass to your part of the field, if thought in that certain way. What you want to do is to get a fence that is stronger, so that nobody can pass either through a hole or through any other weak part of your fence. In this case, what you create is a portfolio that covers all the things that you have already detected are lacking in your core IP, so that nobody can enter eventually. When thinking about defensive, one of the most important things to acknowledge is that defensive portfolios must be renewed on and on. Because as we have already explored, there is always a way to circumvent a patent, and the same way with new patents that are defensive for your core IP. So in these terms, you have to make more and more fences as it is possible to you in order to create an effective defensive IP strategy. The other type of IP strategy is an offensive one, and this is called commonly a preemptive strike. So basically what you want to do is to know your field of action and to know where is the game going to be played in future years. So probably you have a core IP and your competition has a core IP too, but you know somehow through technological watching that the game technologically is going to be played somewhere else. That might steer away a little bit from your core IP and from your competitions. In this sense, what you want to do is to early on attack or preemptive strike this new production direction or space with new IP. And what you want to do is to create a fence again, so that the core IP of the competition cannot pass to that new field of action. With this, this is called an offensive because you're striking before everybody starts attacking that field. But at the very end is also a type of defensive strategy, since you're creating a barrier for others to enter into that space in which you strike at first. Nonetheless, to think it as an offensive IP strategy is the best way to think about it. Finally, there is a type of offensive IP strategy that is called a bridging. And more than an offensive strategy, it's a collaboration strategy, I believe. What you want to do is that you are the innovator and there is a competition that probably is larger than you, or at least equally large than you. But what you do is that you create something that is required for both to collaborate in a single project. So there are sometimes inventions in which someone has a very critical part of the invention and someone else has another critical part of the invention, and they only need a bridge technologically to make them work together in a synergy to make an even better product than the sum of each one. In this case, if you are the innovator that creates this bridge between competition and the innovator, you are basically creating an offensive strategy in which you are forcing the competition to collaborate with you, because you have the secret sauce to make something even more valuable than the sum of their respective parts. And that's something that innovator might opt to do, since it's something that encourages collaboration and, of course, a win-win value proposition. And with this, we have explored the basic principles of IP strategy, IP value generation, which comes from business, and of course, the different IP spaces in which you might be working on. If you have any doubts about any of the information that we have explored today, please refer to the chapter on implementation on IP strategies from our Biodesign book from CNews and Stanford Biodesign. My name is Luis Soengsen, and thank you for watching.